What if I told you that there's a tax form that could quietly prove your debt was settled without you even paying a dime the way they want you to? Now, most people have never even heard of the 1099 OID, but it can be a game changer in a debt discharge strategy. In this video, I'm going to show you how the original issue discount reporting works, how a debt instrument can trigger OID events, and how to leverage the IRS reporting rules to your advantage. So we'll break it down in plain English. You dig what I'm saying? And connect it to real world settlement scenarios and show you where the law actually supports it. Now, before we dive into this video, this is not legal advice. This is not financial advice. Remember to do your due diligence. You dig what I'm saying? Remember to tap in to the information even after watching the YouTube video. You get what I'm saying? Don't get excited. Get motivated and empowered to go look it up on your own. Don't just trust me. Find the truth. Number 2. If you're brand new, hit the like button, hit the subscribe button, tap in. Okay, this is going to be a very detailed, but we're going to try to get through this video relatively quickly. Okay, now, first things first. All right, what I want to talk about is what a 1099 OID is. Okay, so real quick, if I pull up a 1099 OID, you understand what I'm saying? A 1099 OID, I mean, let's pull up an image. 1099 OID looks like this. Okay, original issue discount. Okay, now for those of you guys who don't know, the OID is literally created when there is a difference from when the lender or the financial institution purchases a bond or note or security to what it is worth when it matures. Okay, so let's just say they purchased something, or they originally issued a bond for 10,000, but then they end up selling it for 70,000, or vice versa. They get it for 70,000, they end up selling it for 100,000. That 30,000 difference is what gets reported on the 1099 OID. Okay, and we can look at the direct definition. It says the tax form is used to report taxable income from the original issue discount on certain debt instrument. The OID arises when a debt instrument like a bond or note is issued at a price lower than it is stated redemption price at maturity. The difference between the issue price and the redemption price is considered a form of interest income that accrues over the life of the obligation. So let's just talk about that real quick. It says, okay. Typically, a brokerage company or other financial institution holding a debt instrument will issue a Form 1099 OID to the investor. Issuers of bonds, CDs, and other deposit arrangements with OIDs are required to file this form if they pay at least $10 in reportable OID or withhold federal income tax. Okay? You can get a lot from here. Investors who receive a Form 1099 OID use it to report an OID income on their tax return, usually as interest income, and the OID is generally taxed as ordinary income. It is important to report the OID's income correctly to ensure the tax compliance. So, it's almost like it's a requirement to report this information. Okay? Now, if we go to a place where it says that it's required, 26 USC 1272-1275, okay, all the way to 1275. You feel what I'm saying? It says that it breaks down the rules of an original issue discount, and it goes all the way to 75. Okay, so whenever you get a chance, review 12 USC 1273 all the way to 1275. Okay, but it lays out the rules of OID. So if you wanted to fully know what the purpose of the OID was, you can go check that law out. It's normally used for bonds, but private negotiable instruments like a promissory note or remittance coupon can fit the definition under certain conditions. So let me just expand upon this real quick, okay? Most people think the 1099 is just for wages, W-2, or self-employment income, which is a 1099 in the NEC, but the 1099 is a very specific form for reporting the original issue discount, what the discount was from when it was originally issued. Okay, so it's the difference. Okay, now if a lender issues the debt instrument like a promissory note and later sells it to someone else for less than its maturity value, that difference is a OID, and it is taxable and reportable. So what does this mean? Okay, If your promissory note or mortgage contract is negotiable under UCC 1-04, and we know the definition of a negotiable instrument means an unconditional promise or pay. Negotiable instrument means an unconditional promise or order to pay under UCC 3-104. That means that it's something that can be used as an asset to the bank. Okay, so then this is when we beg this question. If it is sold, traded, or deposited at a discount, there's a taxable event for whoever gains from it, and it should be documented. Okay, that documentation can create a public record that the debt has already been settled in another way. So a trigger of an OID event now will beg the question, dang, if there's an OID that was triggered, then that means that they sold it. So if they sold it, then that means that they made money on it. That means that it was settled. If it was settled and they still attempt to collect on a debt from you, then now we're talking about double recovery. We're talking about something that can be considered unlawful. All right. So here's why it matters when it comes to debt discharge. Okay. When you are moving and using the OID as a strategic angle, all right, is that if the lender or servicer has sold or transferred your debt instrument at a discount, that means they've already been compensated in whole or in part for the value of your note. So if anything, if they've been compensated, then I should be paying whatever is left, the difference. 2, under commercial law, they may no longer have valid claim to the same amount from you since they monetized the obligation. That's 2. Why this matters for discharge. And number 3, if they fail to disclose this and continue to demand full payment, it could be construed as double dipping. Okay. Now, how this ties to the discharge strategy? Number 1, if you can document that the OID event has occurred and it supports an argument that the obligation was already satisfied, then you now have a case where they've already made money in commerce. Okay. Number 2, the 1099 OID can also act as an affidavit of fact as a formal notice to the IRS and the lender that a certain financial event has happened and you are reporting it. Okay, so you can use this 1099 OID as evidence that somebody has sold it. Okay. Now, in some private remedy strategies, you can use this form paired with a 1099A, acquisition of property or abandonment of secure property, and a form 1096 as a part of a reporting package. Now, only do this if you're going to do it through your trust. Okay. Now, when you look at 26 USC 6049, it says that when to every person who makes payment of interest, who receives payments of interest, shall make a return according to the forms or regulation prescribed by the secretary. So when you decide to get an interest payment, you must file it with the IRS. If they use the OID, they must file it. Okay. So the information is out there for public. And then if we go to 26 CFR 1.1273-1, it breaks down a definition of an OID and it lays out how to determine the amount of an OID. Okay. There's also case law that recognizes 1099 forms being admissible as evidence when unchallenged, especially if the counterparty fails to rebut them. And also under UCC 3-305, not UCC 3-303, UCC 3-305, right here, you have the ability to defend yourself against claims that are not considered enforceable. Okay, you can challenge the enforcement of something that's already been paid, discharged, or the obligation has been altered. And we can easily argue that because of the 1099 OID event has happened, that meant it was sold. So there has been a payment, some level of discharge, or the obligation has changed in some way, shape, or form. Okay, so now the other question that you'll ask is how to identify when an OID has occurred. Okay, number 1, you want to track the paper trail. Okay, if they have triggered an OID event, this is how you want to uncover it. By simply, well, I won't say simply. Okay, let's just say if it's a secure transaction, you can use UCC 9-210 to request for accounting regarding the list of collateral or statement of account. You have a right to request a verification of the debt, including the itemized accounting of all transactions related to your notes. So if you wanted to see the original amount financed and the current balance differ due to a sale or assignment, they must provide that. When you use UCC 9-210, it's a demand. Okay? You are demanding it. So they are under contract to be able to provide that to you. I also did a video on being able to find this in the SEC filing base. Okay. SEC.gov. You can come to SEC.gov. You can type in the company and the company will pull up and you could be able to see if they have any pooling and servicing agreements. Okay, filed with the SEC. If there's any pooling and servicing agreements, that means that it's potentially bundled into a mortgage-backed security or asset-backed security. Okay, so this is how you can find out if there was if there was anything that happened behind the scenes about your debt. This is the Edgar on the SEC's website that you can literally use to do a full search of that company. You just type in that company or that debt collector and you may be able to find information on them using the Edgar's database. Okay. You can also look for under UCC searches and see if they have filed a state level UCC financing statement. Okay. If your note was securitized, there's often a chain of assignment recorded as collateral. Okay. So you can be able to get that information on the back end. Obviously, you can ask them directly, but sometimes they don't give it to you, or most times they don't give it to you. So you can go do these things to be able to find out yourself. You can also ask the IRS for the records and send a Freedom of Information Act request. Okay, you can send that to request to the IRS to provide any 1099 forms filed in connection with your name or your SSN for that tax year. If a 1099 OID exists and you never received it, that's a powerful piece of evidence. Okay. So then we dive into the actual strategy to use a 1099 OID. Okay. Now, before we dive into this, when I break down this actual strategy, you must, I repeat, you must follow directions. Okay. And research everything on your own. Go look at the law and make sure you understand the legal merit behind this. The legal merit being UCC 3-104. The legal merit being 26 USC 6049. The legal merit being 26 USC 1272. Okay. The legal merit being the court cases where 1099s were present and used as evidence. Okay. Because everything that you do has to be backed by actual facts. Okay. So let's just break this down on how you can be able to use this practically. Okay. Now, when you use the 1099 OID in the remedy strategy, this is where your theory is going to meet action. Okay. But you got to make sure to do this cautiously because the misuse can lead to trouble. So the key is to make sure you have a lawful and documented process. Okay. Number one, you want to establish the facts first. Don't file anything with the IRS until you have confirmed that an OID event has happened. If you don't confirm that, then you are putting yourself in a detrimental position. So you want to have at least 2 independent sources confirming that your note was sold at a discount. Whether you ask them directly and they provide that truth or not provide the truth, or whether you check the SAC filings or you send in a Freedom of Information Act request to the IRS. Okay. Number 2, you want to prepare an affidavit of fact. You want to state the sequence of events, the issuance of the note, the transfer of the sale, the discount, and the identification of the OID. You want to attach any exhibits if you have any pooling and servicing agreements, right? UCC filings, any correspondence from them, right? Any letters that you have sent asking about the accounting and their lack of response. You want to prepare an affidavit of fact and you want to include any exhibits. Number 3. When it comes to the 1099 OID filing, in certain remedy approaches, a debtor reports the OID to the IRS as the original issuer of the note, asserting that a discount was effective income from their asset. This often is accompanied by a 1099A to show the acquisition or abandonment of collateral or property, and a 1096, which is the summary, okay, of what was filed. All right. Now, your evidence must be airtight because the IRS can prosecute you for doing something fraudulent. So if we go to, and I talk about this in my video yesterday, Okay. 18 USC 514, fictitious obligations. Whoever with the intent to defraud draws, prints, processes, passes, utters, presents, offers, brokers, issues, sells, utilizes interstate commerce, foreign commerce, including use of mails or wire, radio, or electronic communication, any false or fictitious instrument, document, or other item appearing, representing, purporting, contriving through a scheme or artifice to be an actual security or financial instrument, shall be guilty of a Class B felony. Okay? So don't just file these and you don't even know what they truly do, what the purpose of it is. Okay? Trust and believe. I've even filed things using 1099s, and luckily I didn't get hit with this. I'm super lucky. But you don't want to file this and potentially they have an argument of you potentially using a fictitious obligation. So they may say this, but in order to combat that, you got to have the legal merit behind everything that you are doing. If you're doing a discharge practice, then you got to be able to bring up the aspect of you using a negotiable instrument. You have to be able to bring up the aspect of you presenting and asking them for their disclosures, right? You have to be able to bring up the definition of discharge and renunciation and cancellation. You have to be able to pull up, hey, look, their tender was refused, so there is discharge. You have to be able to pull up the definition of tender, which means to unconditionally offer money or performance to meet an obligation. All you're doing is attempting to perform. Now, if you're performing incorrectly, then tell me how I can perform correctly, how I want to perform. Don't tell me that I only can pay with legal tender, and legal tender is an unconditional offer of money or performance to meet an obligation. Okay? So you don't want to, if you're going to do this, you want to make sure that your evidence is airtight and your knowledge is airtight too. So if they come back and they say, well, what you're doing is fictional and you can't rebut to that, then it's going to stand in truth. All right. Now, once you have established your facts, prepared the affidavit of fact, understand about the 1099 OID filing, you gathered information on that, you want to then send the notice to the creditor or collector of the information. Okay? You can send a conditional acceptance or a notice of settlement stating that the obligation has been satisfied in commerce and demanding updated accounting. Hey, I noticed that you guys have already settled this. You've already discharged it. And unless you haven't, I'm going to assume that this obligation has been satisfied already. And I demand that you update the accounting and send me the information. You have a right to do this. Okay? Now, if you do all of this, right, you can take them to court if you build up enough evidence to be able to challenge them in court. So you'll have some leverage in litigation because in court, you can use the evidence of the OID to challenge standing, claim double recovery, and raise equitable defenses under UCC 3-305 and UCC 3-602. Okay? So the OID is really evidence. Some people look at the OID and think that, oh, if I file this OID, then my debt is going to be discharged. No, it's not that. People will say, oh, there's an OID method. No, it's not an OID method, okay? It's evidence of something that you can use against them when you are challenging whether or not the contract is enforceable or not. Because if that contract says that you owe me, right, I should have lent you actual money. And I should be only getting the money from you. But if I got the money for someone else, that right there nullifies the obligation. If you was able to take our obligation and monetize it, that nullifies the obligation. Why? Because you forfeit your ability to collect, okay? But then on the other aspect, let's say you bring up these concerns, right? They're able to prove, okay, we didn't make money, and then you challenge on whether or not your note or your tender was something, or you use a tender, right? A tender of payment, and they refuse it. They also forfeit their right to collect as well, okay? But before I send you my tender, I want to send a conditional acceptance. I want you to prove that you are even in a position to collect, okay? So one more time, we're going to break down that practical application. Number one, you want to identify the note or coupon, whether it was traded, sold, or securitized. You want to draft the 1099 OID showing the discount amount as interest income to you. You want to then send copies to both the IRS and the credit servicer. Number 4, you want to give them a chance to rebut because their silence equals tacit agreement. So it's okay for you to send them a letter and they don't respond. This only makes it worse for them. And then you want to maintain all your certified mailing receipts for evidence. Okay. Number 4, all the legal merit behind it is everything that I just brought up. Okay. The definition of tender, 9-210, requesting for accounting. We can also go to 15 U.S.C. 1611, criminal liability for willful and knowing violation, giving false, inaccurate, or failing to provide information that they are required to. PC 3-302, challenging whether they are the holder in due course, given the fact that there was an OID event triggered. Okay? C3-603, tender of payment. C3-501, demanding and presentment. Evidence of dishonor. They ignore you. That's considered dishonoring. 26 U.S.C., the definition of an OID, okay? And where one should be reporting information. Negotiable instrument. I mean, I can go down the list. There's so many things I can pull up, okay? So the OID is real. It's not in a sense of you using the OID to discharge your debt, but it gives you records that debt has been discharged and you would use it against them. So make sure you're staying in honor. This is not a magic paper and it must be backed by actual facts and transactions. Number 2, there are IRS penalties for false filings, okay? Use only when you have proper grounds and legal merit and you understand the legal merit. And the goal is to have the documentation. You are not trying to evade taxes or evade paying your bills. You are moving with honor and documenting when they dishonor you. You're documenting when they are not complying. Why should you comply to a contract that they are not complying to? You get what I'm saying? It's about equity. It's about fairness. All right. So if you want me to dive in, okay, you want to learn more about the OID. Okay, I put together a 1099 OID discharge starter kit for you in the school community. And you can tap into the school community for free for 7 days. And you can be able to get that 1099 OID discharge starter kit. Okay. So you can learn the ins and outs and how to properly do this. Everything I talked about in this video will be in written form in my school community. The link will be in the description. Okay. Number 2, if you want to work with me directly, make sure to hit the application button under the school community link. But it's only for people that are serious about fixing their credit and getting funding. I'm not a direct coach when it comes to discharging debt. You can sit and have a one-on-one call with me, but I would suggest you start in the school. Take a look at the school. If you feel like you need more value after that, then reach out to me on school. Okay. I think at this point, only people that come through the school and message me through the school, I will probably take those people more serious. Okay. Obviously, if you're in the Discord, tap into the Discord. I love y'all on the Discord. Y'all don't fall short of that. Okay. Check me out on Instagram and on Twitch at biz.nick and biz_nick. And lastly, man, if you've gotten this far, man, let me know if you guys have had what your ideals are on the OID, how you guys have used it. Drop some game in the community. Other than that, I love you guys. Thank you guys for watching this video. Remember to hit the like button, hit the subscribe button, and I'll see you guys in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the Academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month if you like it. No fluff, just facts and just freedom. Go to thefundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.